5 years. Its paint is faded.
All right. Peace to Yahoo. Peace to Yahoo. I'm just getting these lives started. Mike. I think it's real wild the way they pushing me out on Blog Talk Radio, yo. I must be doing something right. They definitely trying to stop a nigga from giving y'all this info for show. Shout out to Shaka. We got some great studying in today. Confirmed some things. We were going back looking at other people's processes, looking at all the shit they were doing wrong and how they weren't following the law. It was very enlightening. In the whole nine, but it's all good. All right, I got one more live to start. Let me start Facebook. All right, I started Facebook. Now, we got an up and coming workshop on the 31st. It's going to be dealing with redemption of your bills. That means your bills will be paid for. Redemption of your bills. I'm going to show you how to redeem your bills, right? By the laws. It will be the laws that tell you, and the process come from the laws. And y'all definitely want to be a part of that, especially with today's economy. You need your bills paid for. And not to mention, if your bills is paid for, you don't have no need for money. But you're still going to work. You're going to work to stack up your money. So you can invest and become even richer. I've already shown y'all how not to pay taxes on the state level, the federal level, with the IRS and everything else. You see what I'm saying? Y'all want to know more about those things, go to jonahbey.com and pick up, the workshops or the webinars that teach you how. But now I'm going to teach you how to redeem your bills or pay your bills with redemption. It's not called set off. It's not called discharge. It's called redemption, right? So I'm going to finish reading that case, the legal tender case. And the legal tender case that I'm reading is Juilliard versus Greenman. We're going to learn about some more. They really don't want y'all to hear this case because it breaks down everything that must be done. But they could slow me down, but they can't stop me, right? Oh, the workshop, it said workshop. If it's a workshop, babes, or if it's a webinar, that says online, right? It's going to be online. Now, let me say this. We're going to do the workshop at 7 o'clock, right? But we have the money ritual at a very nice hotel lounge. We're having that starts at 10:30, and we're going to do the money ritual at 12 a.m. Get your money right. You see what I'm saying? So technically, for some people, it's going to be, the workshop is going to be online, but y'all see me in person on later on that night. Anyway, I'm getting the flyer made for the money ritual. Should be done today or tomorrow, tonight or tomorrow. And I'll put that up on social media so y'all can get involved in it. Now, and of course, the workshop is $171. I made that number because it signifies 9. 9 is the number of completion. 9 is the actual last number of numbers. And then it starts repeating. That's what 10, 11, 12, 13, all that's just a repeat. Anyway, but the money ritual, it'll be free for y'all to come chill with us at that party at the hotel and all that. All right. So I'm reading the case called Juilliard versus Greenman. It happened in 1884, Lincoln's time, how they structured the greenback. Right? What y'all got to realize is they could only have 300 million treasury notes in circulation. Do you know we have over 300 million people in the United States, closer to 500 million, with all the foreigners that just came in across the border, right? 500 million, 500 million. Now, if you only got 300 million treasury note in circulation and must stay in circulation, how would people have money? Even if it was just 300 million people and $300 million, that means everyone would only have $1 to spend. So they had the necessity to use their credit and expand with a greenback or an internal credit system or an IOU. And today y'all call them Federal Reserve notes. They have no choice but to expand the money as more people are born, right? So it was necessity. The biggest problem y'all having is y'all don't know how to do redemption. And y'all definitely don't know how to redeem your bills. So that's the problem. The system is there in place because it has to be, and it's necessary. Now, I bet y'all didn't hear no one tell you that before. Now, this guy in this case didn't understand the necessity. Now, let's say if now the treasury money that's in effect is your dimes, quarters, pennies, nickels, right? Let's say they didn't have the paper form, the paper bonds, the paper notes. They didn't have none of that. That means the 300 million would be in coins. Even if it was in gold and silver coins, there's not enough gold and silver coins for people to do commerce when the people in the nations, the number keeps on going higher. No one would have any money. Right? It's a necessity. I have to tell y'all that. It is a necessity, right? So now we have that 300 million is in coins and it's in notes, treasury notes. But you'll never be able to use the treasury note side without learning how to redeem Federal Reserve notes. All right, so let me get to reading. It says, I'm on section 20. It says, by the Articles of Confederation of 1777, the United States and Congress assembled were authorized to borrow money or emit bills on the credit of the United States. See? Articles of Confederation, the very document that helped create United States of America. It's the foundational document. It's a treaty. It is above the Constitution. It is considered the original Constitution. But before the Articles of Confederation, it was the Articles of Association. Right? Now, it gave them permission to make money, aka greenbacks. It says borrow money. It can borrow money or emit bills on the credit of the United States. That means on the credit of you guys. The people are the United States altogether. When you're in the republic, But it was declared that each state retains its sovereignty and freedom, which takes me back to the law that tells you whether you want to pay taxes or not. It's voluntary. I gave y'all the law. I also broke down how to use that law if you don't volunteer to pay them taxes. But let's go on. But it was declared that each state retains its sovereignty, freedom, and independence in every power, jurisdiction, and the right which is not by this confederation expressly delegated to the United States and Congress assembled. Article 2, Article 9, Section 5, 4, and 7. Yet upon the question whether under those articles Congress, by virtue of power to emit bills on the credit of the United States, had the power to make bills, so emitted a legal tender. Chief Justice Marshall spoke very guardly, saying, Congress emitted bills of the credit to a large amount and did not, perhaps could not, make them legal tender. This power resided in the states. Craig versus Missouri. But in the Constitution, as he had before observed in McCullough versus Maryland, there is no phrase which, like the Articles of Confederation, excludes incidental or implied powers, and which requires that everything granted shall be expressly and minutely described. Even the 10th Amendment, which was framed for the purpose of quieting the excessive jealousies which had been excited, omits the word expressly and declares only that the powers not delegated to the United States nor prohibited to the states are reserved to the states or to the people, thus leaving the question whether a particular power which may become the subject of contest has been delegated to the one government or prohibited to the other depend on the fair construction of the whole instrument. So that was a very broad way, legal ease way to tell you do what they were doing today under the Articles of Confederation. So they made the Constitution and took out certain words so that they would be able to make United States notes, greenbacks. And they further had to have your man Abraham Lincoln put it into play when he made the emergency of the Civil War. Then they were finally able to make greenbacks. They changed shit up, bro. But they quickly realized they didn't have enough money circulating around for people to do commerce. That's why they had to. Okay, let's go on. Even the 10th Amendment, which was framed for the purpose of quieting it. Okay, I read that part. Hold on. Thus, leaving the question whether the particular power which may become the subject of contest has been delegated to the government or prohibited to the other, to depend on fair construction of the whole instrument. The men who drew and adopted this amendment had experienced the embarrassments resulting from the insertion of the word in the Articles of Confederation and probably omitted it to avoid those embarrassments. 405 and 406. is the case. You can go look it up. The sentence sometimes quoted from his opinion in Strudge versus Shield had exclusive relation to the restrictions imposed by the Constitution on the powers of the state, especially reference to the effect of clause prohibiting the states from passing laws, impairing the obligation of contracts, as will clearly appear by quoting the whole paragraph. Was this general prohibition intended to prevent paper money? We are not allowed to say so, because it is expressly provided that no state shall emit bills or of credit. Neither, so what they said was no state, no Georgia, New York, California, none of them could create money. The federal government, Congress could emit credit drawn on from the people, the United States. You understand? Only the federal government could. That's how the foundational documents, the Constitution, the Articles of Federation, the Articles of Association was framed. That's what it is. Let me go on. Neither could the words be intended to restrain the states from enabling debtors to discharge their debts by tender of property of no real value to the creditor. Did y'all hear that? They said if you're a debtor, you can give them promissory notes of no real value. And you still got that power today. Because of that subject, particular provision is made. Nothing but gold and silver coin can be made a tender in payment of debts. 21. Such reports have come down to us of the debates in the convention that framed the Constitution afford no proof of any general concurrence of the opinion upon which the subject before us. The adoption of the motion to strike out the words and emit bills from the clause to borrow money and to emit bills of credit of the United States is quite inconclusive. In other words, it was ambiguous on what they could and couldn't do. So they struck out certain words to make it where they could do it. All right, let's go on. The Philic delivery before the Assembly of Maryland by Mr. Martin on the delegates from the state who voted against the motion and who declined to sign the Constitution can hardly be accepted as satisfactory evidence of the reason or the motives of the majority of the convention. C. Eliot, DEB 345, 370, 376. Some of these members of the convention, indeed, as appears by Mr. Madison, minutes of the debates, expressed the strongest opposition to paper money. And Mr. Madison had disclosed the grounds of his own action by recording that this vote in the affirmative by Virginia was occasioned by the acquiescence of Mr. Madison, who became satisfied that striking out the words would not disable the government from the use of public notes, so far as they could be safe and proper, and would only cut off the pretext of paper currency, and particularly for making the bills a tender, either for public or private debts. But he has not explained why he thought striking out the words emit bills would leave the power to emit bills and deny the power to make them a tender in payment of debts. See, he left it ambiguous, even though he objected. And it cannot be known how many of the other delegates by whose votes the motion was adopted intended neither to proclaim nor to deny the power to emit paper money, and were influenced by the argument of Mr. Gorham, who was for striking out without inserting any prohibition, and who said, if the words stand, they will suggest and lead to the omission. The power, so far as it necessary or safe, will be involved in that borrowing. 5 Elliot DEB 434, 435, and a note. And after the first clause of the 10th section of the first article had been reported in the form in which it now stands, forbidding the states to make anything but gold and silver coin to tender in payments of debts, or to pass any law impairing the obligation of contracts by Mr. Jerry, as reported by Mr. Madison. See, so now, do y'all understand what went on in history? Think about it. The states could only use gold and silver. What did the states do? They created the federal government, right? 1871 is when they created the so-called Constitution for the federal government. So when they created the federal government in Congress assembled, they could pay things without it being gold and silver. They could make greenbacks and it would be lawful money or treasury notes. See, to fix the problem and do redemption, you got to know the history. Most of y'all have never been taught the history of money. Y'all have never read these cases. This is the actual history of money, going from each foundational document of this government. They had the problem from the beginning. It was a corporation from the beginning, United States of America. I didn't say it. This case is saying it as well. All right. Let me go on. And after the first clause of the 10th section of the first article had been reported in the form in which it now stands, forbidding the states to make anything but gold and silver coin to tender payments of debts, or to pass any law impairing the obligation of contracts, when Mr. Jerry, as reported by Mr. Madison, entered into observations in calculating the importance of public faith and the priority of the restraints put on the states from impairing the obligation of contracts, alleging that Congress ought to be laid under like prohibitions, and made a motion to that effect. He was not second. So everyone wanted to put that same prohibition on the federal government that they wouldn't be able to make paper money either. No one agreed with him, right? And made the motion to that effect. He was not second. ID 546. As an illustration of the danger of giving too much weight upon such a question to the debates and the votes in the convention, it may also be observed that propositions to authorize Congress to grant characters of incorporation for national objects were strongly opposed, especially as regarded banks, and defeated. ID 440, 543, and 544. The power of Congress to emit bills of credit, as well as to incorporate national banks, is now clearly established by decision to which we shall presently refer. So that's when they got the power to print greenbacks and to open up banks to make greenbacks. It wasn't enough gold and silver for people to do commerce and trade back and forth and pay for things. It was a necessity. Let's see. 22. The words to borrow money, as used in the Constitution to designate a power vested in the national government for the safety and welfare of the whole people, are not to receive that limit or restricted interpretation and meaning which they would have the penal statute or in the authority conferred by the law or by contract upon trustees or agents for private purposes. The power to borrow money on the credit of the United States is the power to raise money for the public use on the pledge of the public credit. and may be exercised to meet either present or anticipated expenses and liabilities of the government. See, they get to borrow money from y'all or anyone else to run the public government or to get it directly from y'all. It includes the power to issue in return for money borrowed the obligations of the United States or any appropriate form of stock, bonds, bills, and notes. You just read it right there. I just read it. All that is considered money, lawful money. Stocks, bonds, bills, notes, or whatever form they are issued, being instruments of the national government. They are exempt from taxation by the governments of the several states. Got it? So it just told you if you are using treasury notes, it's exempt from all taxes. Don't you think it's imperative that y'all are using treasury notes? You won't be able to get any treasury notes unless you know how to do the redemption. You need to know how to turn your Federal Reserve notes in to get treasury notes, right? It's imperative. Ain't nothing you could do about it. All right, let me go on. For the safety and welfare of the whole people are not to receive that limited, restricted interpretation and meaning which they would have in a penal statute or in authority conferred by the law of contract upon trustee or agent or private purposes. The power to borrow money on the credit of the United States is the power to raise money for the public use on a pledge of the public credit and may be exercised to meet either present or anticipated expenses and liabilities of the government. It includes the power to issue in return for borrowed money the obligations of the United States in the appropriate form of stock, bonds, bills, notes, and in whatever form they are issued, being instruments of the national government. They are exempt from taxation by the governments of the several states. And the laws that said that is Weston versus Charleston City Council 2 PET dot 449, Banks versus Mayor 7 WALL Wall dot 16, Bank versus Supers 7 Wall WALL dot 26. Congress has the authority to issue these obligations in a form adapted to circulation from hand to hand in the ordinary transactions of commerce and business. In order to promote and facilitate such circulation, to adopt them to use as currency, and to make them more current in the market. It may provide for the redemption in coin or bonds, and may make them receivable in payment of debts to the government. So you have to be able to redeem them things, and the government will either give you coins or bonds. Now, ever since they did the Emergency Act of 1933, they're not going to give you gold and silver coins no more. They're going to give you treasury notes. In other words, bonds, notes, paper money. That's what they're going to give you. All right. Now, like I said, don't get mad at Jonah. Jonah ain't saying this. This is what this case law from 1884 is telling y'all. I'm taking my time to read it to y'all so y'all will know, because I could tell y'all to read it. I can't trust y'all to read it. Y'all are running around with all this misinformation by all these teachers instead of reading the actual cases and the laws that tell you exactly what to do and how to do it. Look, if you got 90% truth and 10% lie, Do you know the whole thing is still a lie? You can't mix the truth with the lies. It won't work to get your remedy. All right. Notice the word remedy and redemption got same vernacular. You know what I mean? All right. Let me find my place. And may make them receivable in payments of debts to the government. So much is settled beyond a doubt and was asserted or distinctly admitted by the judges who dissented from the decision in the legal tender case, as well as by those who concurred in that decision. Visual Bank versus Fino, 8 Wall, 533 and 548. Herpern versus Griswold, ID. 616 and 636. Legal tender case 12 Wall, 543, 544, 546, 582, 610, 613, and 637. All the cases. There's mad cases on this shit. This is probably one of the first cases you've ever heard being read about legal tender. Anyway, it is equally well settled that Congress has the power to incorporate national banks with the capacity for their own profit as well as for the use of the government in the money transactions of issuing bills which under ordinary circumstances pass from hand to hand as money at their nominal value, and which, when so concurrent, the law always recognized as good tender in payment of money and debts. See, now, it just told you they had the right to create national banks, and national banks would be the ones issuing these bills of credit, greenbacks, and all that. Now, Congress is the same people that also hired the Federal Reserve to issue those bills, those Federal Reserve notes. They just put a middleman in between you and them, right? This ain't what I said. This case law is telling you. The judges are telling you of the Supreme Court. All right, let's go on. Unless specifically objected to at the time of the tender, U.S. Bank versus Bank of Georgia, 10 Wheat, 333, 347, Ward versus Smith, 7 Wall, 447, 451. The power of Congress to charter a bank was maintained in McCullough versus Maryland, 4 Wheat, 316, and in Osborne versus U.S. Bank, 9 Wheat, 738, chiefly upon the ground that it was an appropriate means for carrying on the money transactions of the government. But Chief Justice Marshall said, the currency which it circulates by the means of its trade with individuals is believed to make it more fit instrument for the purposes of government than it could otherwise be. And if this be true, the capacity to carry on this trade is the facility indispensable to the character and objects of the institution. 9 Wheat, 864. And Mr. Justice Johnson, who concurred with the rest of the court in upholding the power to incorporate a bank, gave the further reason that it tended to give effect to the power over the currency of the country, which the framers of the Constitution evidently intended to give to Congress alone. See? They had to do it. They had to do it. So let me go on YouTube and see if y'all got any questions up there, and read some of the comments and all that instead of just keep on reading. This is Consultation Wednesday, where I like to answer questions. Oh, thank you, J Mac. He said that suit color is on point. Thank you, my brother. Yeah, it's on some winter shit, y'all. Uh, Shirt is 100% cotton. The tie and handkerchief, 100% wool. And the suit is corduroy. Got to dress according to the occasion of the season. You know what I mean? Appreciate you. This is called the old money look. My money is because I have money so long it's becoming old money. You know what I mean? Oh, what's the call-in number? Sorry, Uric, there is no call-in number because Block Talk is blocking my call-in numbers. They bugging. This is the second show they did that on in a row. Peace, Jonah. Peace, Stephanie. Terrence Love says, Ashe can't stop us though. Nope, they can't stop us. We're going to keep on teaching. Study Man said, Ramsey Bay here, peace to Yahuwah. Peace to Yahuwah. Yokan, all of them said peace to Yahuwah. I Create says, I put in discovery for someone on a traffic case. Afterwards, found out they had a video conference court date in January. Should I deny the conference or just let the discovery take its course? You have to put in an affidavit saying you are denying a conference call. It is a violation of your due process. The Constitution protects your right to meet your accuser. You cannot meet an accuser face to face on a video call, especially with today's technology. You could be talking to AI. Now, also, if you're on a conference call and you want to object, do you know they can hit the pause button on you or the mute button where they can't even hear what you're saying and it won't go on the record? See, when it's a video call, it can't be a court of record, which is another violation of due process, right? Never, ever, not even once, do anything by video. Hell no. They want you to waive your rights. And obviously, if you allow them to do that, have that conference, you didn't know you had the right to meet your accuser. You didn't know you had the right to have a record, have it a court of record. All right? Peace and respect. Peace. Marlon Walker said, good looking, brother. Thank you, my brother. I'm getting old, though. I'm just getting my old man on. This is the way someone who's 53 and a grandpa is supposed to dress. Chevron difference, ambiguity. Yes, you're right, Christopher Harris L. The Chevron difference says, you can't have all these agencies just making rules, regulations, and statutes. If Congress must be clear on what they want in their intent. So they need to make the actual law, which is called positive law. Anything that's made by an agency is not positive law. It's just a rule and regulation. Only Congress and the legislature gets to make real law, right? And they're trying to not make the laws because some of those laws, most of those laws are going against the Constitution. So they wanted to put it on the other people. Plausible deniability, right? The Chevron difference turned that backwards. It's not allowed no more. Yeah, well, see, Christopher Harris L said we got to get back to pre-1933. Pre-1933 is what Chevron difference just did for you. But as I'm reading that law on legal tender, you see way before 1933, they had the issues with money, where is it acceptable, how to redeem it, and all of that. You need to know the history to be able to utilize the laws. The laws and your redemption has always been there and still is. They could never take it away. Let me tell y'all a secret. You know, everyone's talking about New World Order, right? They're talking about cashless society, right? Um, well, if you read that law, this case law that I just read, do you know it said that they can never ever get rid of the 300 million treasury notes in circulation. If they take one away, they got to replace it with another one of the same denomination. There will never, ever, ever truly be a cashless society here in America. It goes against the Constitution. It's not allowed. But y'all will have to know that. And y'all also have to know how to redeem. Just a protection that y'all have, and hopefully right now you know you have it. And y'all will utilize it to protect yourself. They're going thing be in my way. Mic drop. All right, let me go on. Peace to the gods. Thanks for your wisdom. You welcome, my brother. Someone said YouTube bugging, no sound. Y'all on YouTube. I know y'all can hear me. Y'all got the ones up. The person that has no sound, shut off your computer, reboot it, and that should make it work. But you can go on to TikTok, you can go on to Instagram or Facebook to hear me as well. All right? Christopher Harris L. He said he can hear it. Uric says, Jonah, you and me go back to PTK. I know who you are, my brother. You came up to me, introduced yourself to me. We started hanging out after all that. Yes, I remember you. I remember your girlfriend. Y'all lived. I think that was Buckhead where y'all lived. I'm not sure if it's exactly Buckhead, but I call that Buckhead. You came over to the crib, all that. Absolutely, my brother. Noble Ramizi El Bay. Peace more. I got a name decree back in the early 2000s, but got my BC and SSN changed to match the de jure name. You don't have a de jure name. What you did is created a straw man, my brother. You have to do a new name change and all that. Noble Drew Ali said, get a new name and do business in the new name. See, the problem is when you got the new name, you added it to the old names that made you a slave to the system. You added it to the birth certificate. You added it to the Social Security. So you just became the straw man again. You did the same thing as if you were Kentucky Fried Chicken. And since they was found to have meat that wasn't exactly chicken, they were sued over that. So they turned it to KFC. And KFC is the exact same company as Kentucky Fried Chicken. That's what you did with your new name and straw man's name. It kept the same number to operate in commerce, which was your social. It kept the same certificate of title, which is the birth certificate. You got to do it over. I suggest you go to jonahbay.com and get a consultation so I can show you how to do it properly and according to the actual treaty. A lot of people think, oh, when I do my name change and I proclaim my nationality, it's just done because I did it. No, it has to, for you to be able to inherit an inheritance, you have to do it by the family name. You have to go by the name and the nationality of the family so you can receive their inheritance. So you can't just make your declaration of nationality any old kind of way. You got to use the names and the words inside the treaty to do that. Just to let you know that, brother. What do you do if the bank won't send you a payoff? I would first read the contract and find out if they have to. See, here's the funny thing. When you learn how to do redemption, you don't need the payoff. You can get it paid off without the payoff. So I don't know why you're harping on the payoff. Perfect example. When you closed on a house, they gave you your closing paperwork, a copy of them, right? And they took the note. Most of the time, they take the note and they put pay to the order of without recourse on the back, right? You could even take the note and close out, redeem and close out, and get it all paid for with treasury notes. You just got to know what you're doing. You got to know the law. That's why I'm reading the case to you. I'm breaking down the case to you so you would know exactly what you can and can't do. All right? Do I need to enter a separate memorandum in support and summary judgment after my affidavit? I have no idea what you're talking about. I have no idea where you learned that from. You didn't learn it from me. What Lord told you to do all of that? See, a lot of y'all are doing processes that these teachers just tell you to do, right? The problem with that is you need to find the law that tells you to do that. If you can't find a law that tells you to do that, then you don't need to do that. It's that simple. A lot of y'all are moving with hearsay. Jonah don't give you hearsay. Jonah gives you the law, and Jonah reads the law with you. Jonah looks up the definition of the words inside the law. So now you can what? Comprehend what the law is saying and do what it tells you to do. I am obedient. Are you obedient? Right now, your question tells me you're not obedient because you don't have no law that tells you you needed to do that. Now, here's the funny thing. When the people I teach do an affidavit and do an affidavit properly by the law, they don't have to do all of that. They don't do none of that, and they win. They get remedy. Follow the law, bro. Marlon said, I have been redeemed. Well, if you've been redeemed, that's good. That means you're not a sinner no more. To be in debt is a sin. You're a sinner when you're in debt. Did you know that? So you're not a sinner. Congratulations, bro. Seemed like you must have been learning from me. Terrence Love says that makes sense. Thank you for bringing to our attention to the case. Yes, it says the Administrative Act cannot override the Constitution, moving ipso jure. I tried to tell you. You got case law that says they can't use that administrative rules and regulations against you. Number one is Constitution. I've been fighting that with the people in this community for years. I keep on getting remedy for people, and other people want to come in and argue with me about shit like that. Don't argue with me. Argue with the Supreme Court. Argue with the Constitution. I know what it says. I know how it applies because I've been studying it for over 20 years. What about you? Yeah, anything that goes against the Constitution, according to the Constitution itself, is null and void. Right? I create. Thanks, Yahuwah. I knew about not doing the video conference meeting your accuser and all that. Just wanted to make sure that denying it doesn't create an argument or a joiner. No, I don't think it does. You're just saying we're not going to have that meeting. We're going to have that meeting in person. That's not an argument. An argument would be like, I'm not coming to have a meeting with y'all at all. All you're saying is we can have a meeting. It's going to have to be in person. I'm not going to make it easy for you to violate me and my rights. I'm going to enforce my rights. So you got to understand the Constitution says you have that right. That's not an argument. That's a right. It's not an argument. Honor, Lewis Lawson, honor, respect, acknowledge your ancestors. That's not mine. I get that from Jonah. True story. True story. How do we hold courts to the $9,000 pay fee schedule? Injunctions and all of that. When you do all your injunctions, they violated, they already agreed to pay you. Then you have to learn how to do a proper affidavit and put in your suit. But all the time I tell y'all have to do what y'all call the administrative process. And then when you do the administrative process, you have to do a notice of intent to sue. You put all that on the record, and then you put in your original affidavit in the court, which is your complaint. And you show the proof that you gave them every opportunity to answer and fix the situation. But like I said, go to journalbay.com. I got all those lessons on the site. I got a notice of suit, webinar or workshop. I got all these things, affidavit. 99% of y'all aren't going into a real court because you don't know how to do a real affidavit. Y'all are doing straw man affidavits. Y'all don't even know the law, which tells you what an affidavit is. How do you think you're going to win? The maximum law, I read it a couple of weeks ago. The maximum law said, if you don't know how to do an affidavit, then you can't have a court. No one can be in court without an affidavit. So y'all only have the goddamn cop or whatever does somewhat a real affidavit, and you never answer it. You always going to lose. Act Writer says, Jonah speaking facts. Law is precise. Yes, it is, my brother. Okay, thanks. I got that webinar, a workshop on the affidavit, already on the study. Good job, Wonder. Good job. Keep on studying. You're going to get it. You're going to bust their ass. We just got to learn more. We got to learn what the actual laws are to enforce them. That's what the point of the lesson is tonight with me reading the case law. You know what I mean? Now, let me see anything on the gram they had. Any questions? Oh, shit. I ain't asking no more questions. We at the end. So, like I said, we got an up and coming workshop on the 31st, 7 o'clock. For tickets, go to journalbay.com. Buy your ticket. You don't want to miss it. Like I said, I'm going to show you how to redeem your bills. That means you ain't going to be paying no bills after that. Maybe you interested, maybe you're not. Maybe you like being broke. I don't. I ain't been broke for a long time. Like I said, I got that old money. So I dress like old money. What about you? All right, with that being said, peace to Yahuwah.